don't take anything, you do it, but you have to do it. Second thing is, when you are handling a criminal case of human rights violation, most important thing, what are the minimum requirements? Visit the site where the offence is taking place. Find out what material you can get there. Then, immediately, if a camera, take photographs of what happened. That Pradam Singh, you had an injury, somebody could take a photograph immediately. I remember in Tamil Nadu, when Tirunelveli incident which I inquired, the 17 people were killed. There was a postmortem. Now, I'll tell you, sad to say, the doctors certified these 17 people were killed by literally blows and so on. Intrinsic evidence is there. The injuries are there on the body. The doctors certified they were all drowned due to drowning, and the body was about to dispose of. Fortunately, human rights activists, two things they did. They demanded, they went to the hospital morgue, and they demanded, we want to take photographs of all these people. So they were allowed. So they took photographs of every dead body. One. Two, they went to the High Court immediately, right to the High Court, and they said, please have a second postmortem. But unfortunately, the High Court, the Chief Justice, I regret to say, would not understand the importance of that. He did not do that. And again the matter was kept pending. Meanwhile, that Chief Justice got transferred. Another Chief Justice came. By the time it was too late, finally of course they could not get an order for a second postmortem. But what they got was the photographs. And on the basis of the photograph, these human rights activists went to other doctors who are well qualified. And what do you think of this? Because some of the injuries the doctors described as fish bite. And because fish bite, but see, it's not a fish bite, it's actually nothing blow. And there's some injuries are so deep and can easily make it. It can't be due to fish bite or anything of the kind. Some are beaten on the bank of the river. So they get all certificate. The case became pakka, a proper case. And this kind of thing. So human rights activists like to do that, of course. They require backing up, as I rightly said, of your group, of your organization, which you are. So they, unlike Meera Paivi, maybe they will be of great help in such a case. Then again, immediately write to the police for any failure in their duty. Put it on record. In the rape case when we went, what I noticed was rape had taken place on 19th of July. And till now, identity inquiry has not taken place. I wish the police, if the lawyers had handled this matter immediately, they should have written to the police of hold an identity parade, call for the record from CRPF office, who are the persons who were there, and insist on identity parade. Something could be done. And whatever you feel, wherever you feel strongly, some direction required, don't hesitate to make an application to the court. So these are the minimum things a lawyer can do in a human rights situation. So the only things that actually required. And if you do this kind of thing, of course your case becomes fakka, that kind of thing. So it requires a little bit of training, understanding of the law, understanding of the procedure, understanding what records are maintained in the police station. You see, in the police station there are a number of diaries. Diary of movement is there. There is a station diary where everything has to be recorded. Then there is anyone put to the lockup, there is a lockup entry diary is there. Insist on all those things. They will not give you, police do not give you. But request the court to summon those records to the court so that you can get it. So these are some of the things you have to think of. And this is what I felt. Lawyers will have to train themselves to be human rights defenders. And of course, it comes by experience, by knowledge, and in the course of time. I think with these few words, I think, tomorrow we will be giving a sort of interim report, prima facie what we are feeling about it. This will be followed by a detailed report, because detailed report will include the various things that we have collected. And today, prima facie our observations, what we have felt, what we have heard, and what we could put on record. These things we will place on record tomorrow and release to the press. And we'll send a copy, of course I have told Babu, they will send a copy to the government concerned and come for an explanation. If an explanation comes, we'll consider that again and come to a final report. And these are some of the things that came to my mind. And I thank you for inviting me here. And I think it's a very useful experience. and I can understand what was going on. I had an invitation to come about 2 years ago. Somebody, I think he met me last year. But earlier, some other group had met me in Pune. There was an invitation, I could not come to this area. Anyway, I'm happy that I could come and see what is going on. And I thought that I could do whatever I could do in this segment. Thank you very much. And, okay, thank you.
Thank you very much, Justice Suresh. It was a very enlightening speech. Justice and his team would be leaving tomorrow, Manipur. It was a very quick trip, very intense trip. No time to spare, not even time for any marketing. Vicky has been very worried about it, so we tried to make a little time this afternoon so that we can also do a little just to see the city around. But the time is short, and I'm sure there are lots of questions which is already coming up in the minds of the participants after having heard this very enlightening speech. If there is any gaps, any questions which have come up, please be quick. Otherwise, tomorrow 1 o'clock is going to be our deadline, and probably the whole day we're going to be engaged in drafting this interim report. Let's now open up the discussion for any queries, any questions that needs to be addressed to the Justice. But as we gather our thoughts and try to frame our mind, let's also hear Priti a little about what they are doing, the groups in Bombay, how they organize the human rights groups, the Human Rights Law Network, the All India People's Tribunal for Human Rights and Environment Law, how the legal community in particular, and of course the human rights community, whether legal or works with as a social movement, how we can collaborate effectively. We think that this input is not going to be just a one-time input, and it should not end with the report that we are going to bring out. It should be a more organic relation which builds up, a solidarity which builds up among the human rights defenders in Manipur and in Bombay and also in other parts of the country, how we can put our heads together and try to fight in our core, in the cause that we believe in a more effective way. So I give the floor to Priti so that she can explain a little of what many people have been complaining. I was telling that Priti has never opened her mouth.
We do. In Bombay, we have the India Center for Human Rights and Law. The India Center broadly is involved with documentation of human rights violations, investigations, campaigning. We also have units that do work on specific issues in the area of gender rights and child rights. In addition to this, we have the Indian People's Tribunal on Environment and Human Rights. Now the IPT, I think Justice Suresh has been with us for a couple of IPT inquiries. The IPT was constituted in 1993. We've done 18 inquiries since then, all on the principle of public hearing. We take our reports, which are then used for campaigning or as part of petitions by the groups. The inquiry panel is always headed by a retired judge from the Supreme Court or the High Court, with a panel of experts depending on the issue that we're looking into. Could be either environment or a human rights violation. Recent example of the IPT report would be pollution in Gujarat that we covered, and that report has now been taken up by the High Court Committee of the Supreme Court, and they've annexed the report as part of their findings. That's briefly about the IPT. Colin will tell you more about the Human Rights Law Network, which is the network of lawyers around the country. In addition to that, just a word of thanks from me. I think some people haven't heard me talk, but I do talk a lot. And I just want to thank everyone for their warmth. It's been a great learning experience for me. I haven't seen army presence like that in my life. I haven't grown up with this around me. This is the first time speaking to the other girls, seeing the kind of freedoms that I have that they don't simply because of the army. It's a little difficult to even fathom how they've grown up in this kind of an environment. But thanks a lot.
Well, before Colin takes over, a short introduction of Colin Gonzalez. Colin Gonzalez, in fact, is the one who is behind the scene trying to a very inspiring figure. What Justice Suresh have just said of what a human rights lawyer ought to do, I think he is probably seeing a role model of Colin Gonzalez in his front and trying to bring out some traits that we already see in him. I personally met him very early when I was a law student and trying to do some work on child labor in Delhi University. That was the first time he gave us a beautiful book on Environment Activist Handbook. I'm sure many of our friends are also getting some of his lovely books which comes out regularly. They are such thick books and very, very resourceful books. From that book itself, you can probably see how the intensity of the work that he puts into the human rights to change the pattern of human rights law across the country. It's not just fighting one case or two cases, but he's at the moment trying to change the whole law, a totally new approach of law in order to defend human rights. He works very hard, but he doesn't work alone. He works with a whole team of people, and he's trying to institutionalize human rights at various levels. In Bombay, they have this human rights law network, which is basically all lawyers who are committed to human rights. They have a visiting card, which is very interesting, with about 10 names and telephone numbers, so that you can contact any of them. It's not just one person, but we should probably try this out in Manipur as well. All the human rights motivated lawyers, you just need one card to put in your pocket, and we can distribute it in the villages where the human rights violations are a problem, and just let people know, and just people can contact the people without any difficulties. They have been establishing human rights law networks all across the country. They have a human rights law network center in Delhi as well, Bombay, and I'm sure in many other small towns. We are looking forward for a possibility. I want to say this, to put it on record in front of our human rights lawyers in Manipur, that Colin Gonzalez is very seriously thinking of doing something with the legal community here in Manipur. And I think I should leave him there. It might be a little embarrassing for him to introduce himself, so I thought I would take up this and introduce him. The rest is yours.
I don't really want to say very much except to say that I'm really grateful for the kind of meetings that we had today and the last 2 days. And we have learned tremendously from the kind of depositions that have been led before Justice Suresh. By the advocates who came here, by the activist friends who spoke, by the women friends of ours sitting at the back who do work in the human rights movement. It has been a tremendous learning experience. It is very easy for us to come from Bombay and to speak to you of human rights. It is another thing altogether to live in Manipur, face the army and do human rights law. Because today you face the army, you face tremendous repression. Many of you have lost, I think, relatives in the struggle for human rights. And I know when I talk to you, some of you say how isolated you feel, or how intimidated you feel, how frightened you feel, how hopeless you feel, how there are no people with you in your struggle. But I can tell you, you are in the foremost of the human rights movement in this country. The Manipur lawyers, the social activists, the teachers, all of you here are in the foremost. You are the leadership of the human rights movement in this country. Punjab, yes. Kashmir, yes. Bihar, yes. Andhra Pradesh, yes. There are fine people like you. But I must say, you have very little to learn from the rest of the country. The rest of the country has very much to learn from you. And it will be an honor to be of any assistance. It will be an honor for me and my colleagues of the Human Rights Law Network to come to Manipur again, to work with you, to perhaps help set up a legal aid center here, to take cases from the Manipur High Court to the Supreme Court regularly, so that the High Court judges also realize that the human rights movement here is capable of challenging orders in the Supreme Court. And it would be an honor to work with you on human rights issues in Manipur. I just thank you very much for this visit. I have not very much to say apart from this, but we will be in touch with you in Manipur. We will come back again and again. And I invite you for the December meeting of the Human Rights Law Network, where human rights activists, lawyers, judges from all over the country will meet at Panchgani in Maharashtra on the 26th of December to the 1st of January. It is an attempt to get human rights activists together for the first time in maybe 10 years, where about 500 or 600 activists, sitting judges of the various high courts, sitting Supreme Court judges, many retired high court judges will come. Because we are living at a time where the right-wing forces, where the forces against human rights, where the communal forces, where the armed forces, where the police are all so hostile to human rights activists. Human rights activists all over the country are feeling very afraid. But we are very large in numbers. Let me tell you that. You may feel in Manipur that you are small, but in the country, the human rights activists, we are thousands and thousands and thousands of activists. Our resources are less. Our money power is less. But our will and determination is very high. Our strength to struggle is very high. And every human rights activist is equivalent to 1,000 of those right-wing gundas. Each human rights activist is equivalent to 1,000 of those people. So we will come together in December. I invite you to come there. We will meet in December. You will see the strength of our numbers, the spirit of our forces, the courage of our people. I tell you, like you Manipur, young activists who have been killed, who have disappeared, who have been executed. You are the finest young people this country has ever produced. You are the finest, you are the most courageous, you are the strongest, you are the most fierce person this country has produced. This is the new generation of leadership of Free India. Or Free Country, whatever it might be. Maybe Free Manipur, Free India, whatever it might be. But you are the new generation of people who 20 years from now will lead India into a new movement, into a new country or into a new Manipur, whatever it might be. It is because of that the army wants to eliminate you. In Punjab, in Kashmir, in Andhra Pradesh, it is the young boys and girls, 20 years old to 35 years old, who are fed up with the old system, who are fed up with the politicians, who are fed up with the judges, who are fed up with the IAS officers, who are fed up with the police, who don't want to just change a little bit here and there, but want to change the entire system, change the entire country, change the entire legal system like we want. It is because this young generation want to change things completely and not compromise with the old generation that the state has taken a decision to physically eliminate you. In Punjab, thousands of young Sikh boys and girls, thousands, 18 years old, 16 years old, 17 years old, eliminated. In Kashmir, young Muslim boys and girls, eliminated. In Andhra Pradesh, young Muslim boys. It is an attempt to physically eliminate the new generation of leadership in India. It's not simply a legal issue. It is an issue of national leadership. And that is why what you are doing in Manipur, situated in a larger context. You are fighting a liberation struggle, not simply a legal struggle. You are fighting a struggle of freedom against oppression that will not allow you to compromise. It will never improve, let me tell you. I am a lawyer, I will tell you, legal system will never improve. I fight within the legal system, it will never improve. Army will never improve, police will never improve, government officials will never improve, not even 5%. We have to radically change this system. We have to radically overhaul the system. And because we young people are dedicated to that, I'm not so young anymore, but the younger generation is dedicated to that, that you are receiving such fierce resistance from the army and the police. So in solidarity we will meet in December. I invite you there. I congratulate you on your efforts. And I thank you for all your hospitality and all that you have taught me during the last 3 days. Thank you very much.
Let's break the system and we can be very informal and ask questions.
I have one question which I want to put forward to Mr. Haisaris. I am Nonibala Hemhom. Sir, you have rightly mentioned in the morning session that there are enough people to protect the army personnel or the police or any government employee when their rights are violated. What I want to say is, whoever violates human rights, it is a violation. So my question is, when the right of a person is violated by what we call underground outfits or extremists, etc., etc., what are we supposed to do as human rights activists? Are we supposed to leave the matter to the government only? I feel it is also the duty of the human rights defenders to come forward to intervene in the matter. These people are also doing the same thing as the army personnel are doing, for example, extrajudicial killings. When I say this, I am not against the underground activists, nor do I have any idea about their goals, their objectives. So when these kinds of things happen, how should the human rights activists step in such a situation? This is my question. Thank you.
If an underground repressive extremist, somebody, if they do killing, so all human rights activists oppose killing. So killing, of course, we will never agree. So you have your right to condemn, okay, killing done by, if you want to condemn, you can certainly condemn killing. Now, the second question is, whom they kill. If they kill somebody who is absolutely helpless and there's no one to take care of that person, certainly you can take up the cause of that person who has been killed. You can certainly fight. But a killing is, suppose a killing takes place, the army or the police car would take up the case, okay, you give assistance to the police. So ultimately, your objective is to see that justice is done to the person who has been attacked, or help the kick and kill of the person who has been killed. Certainly you can do all those things. When we say that the police officer is killed, we don't treat it as a human rights issue in the sense, not that we approve killing, we don't approve killing. What we say is, as far as the police officer is concerned, okay, the government is there to take care of him. And the government is the government will take care of the person, and government will fight on his behalf. This is what we are trying to say. And we don't have to waste our time and energy on that. But a poor man is killed, and the police say he might have been killed by the insurgents, and the police do nothing. The man is left to, and he's helpless. He can't go to a court, he can't go anywhere. Don't certainly take up his case. Don't wait till somebody comes, if you get help, certainly do it. There's nothing wrong in what you are doing. This is what you think.
Right activists are always condemned the act of killing innocent by these underground boys, and for that purpose I myself strongly oppose these underground peoples, and I have already condemned in front of the people and through public meetings. For example, we condemn the killing of Yaiko, which was a family of one Oza Dausi has already been killed by an extremist group. We condemn that. The Ansu was there, and the Marapaidis was there, and I was there. So we generally condemn. We condemn the killing of the 3 Kabuis and 2 Maitais by one of the underground outfits. We condemn like anything. We form associations and we protest at the Thau ground. It was led by some peoples of the Amuko, Koha, and some Marapaidi groups are also there. So we have already condemned the killings of the extremists and the killing of the undergrounds to the innocent people. We generally condemn. We don't afraid of that. I myself condemn the innocent killings by the undergrounds. Thank you. The young peoples of Manipur generally fight for a struggle for the national liberation movement, because before the Manipur was merged into the dominion of India, erstwhile dominion of India, before 1949, Manipur was a sovereign and independent state. It was also observed by the Supreme Court in various rulings since 1953 to 1993. We have heard. So what in your opinion, what is your view regarding the national liberation movement by the young peoples of the Manipur here? What is it?
I said it yesterday on the first day. I have always felt the government must decide whether they want the territory or whether they want the people. If they want the territory, of course, then they have no regard for the people. But if they want the people, then they must understand what the people want. I went to 1995, I went to Canada. At that time, Quebec, you must have seen a province in Quebec. It's their French-speaking people. And they have been carrying on education for years together as for independence. What did the government do? Of course, some killings and things were there, riots were there. But finally the government said, no, we'll hold a plebiscite, a referendum. And then 1995, when I went there, sometime in March or April, the referendum was going on. And finally what happened was, those who wanted independence, Quebec lost by 1%. And their south has been really far. But that is civilized way of doing it. Kashmir, this is what I have been telling. But that's why you were not allowed to speak on Kashmir. This is what I have been saying. In Kashmir, the government must decide what do they want. You want a territory or you want a people? You want the people, then find out what the people want. Finally, you have means to ascertain what the people want. It may take some years, but do something of the kind instead of continue the policy of repression. Same thing here also. What the people want here, that is to be ascertained. And that can be ascertained, not a very difficult proposition if they really want to ascertain what the people want. And I think there should be no problem on that. But unfortunately, that takes us to the other problem. Namely, how do we look at our federal state? What real federalism is there in this country? In what way, say for example, in America, when you say set up federal state, each some of the states have their own constitution. There is nothing wrong in that. Kashmir has its own constitution. We scrapped it off. And now the problem is there. We are not prepared to consider whatever autonomy they wanted. This kind of attitude. So how do you solve the problem? So we will not solve the problem. We will only continue to kill people. This is what is going on. So this, whether you want liberator or not, can be ascertained, not little talk. If the government has genuine intention to see that ultimately peace should prevail, I think this is what the government will say.
Then,
excuse me,
I will add one more.
Yeah.
What is the legal status of the National Liberation Movement? That means...
that's okay. Now this is exactly a point. What is the legal status? I can say, if there is a law prohibiting your activities, because that's the law. Your freedoms are guaranteed in Article 19 or Article 2021. Okay, if that law, to what extent it restricts you, subject to that. But forget the law. Government always brings a law. Whenever you want to, you maintain the Internal Security Act, something of the kind, some law will be brought, see that you are not allowed. The question is not that. The question is, constitutionally, what is the right of the people? Can there be, this is one of the concerns I will see recently, our High Court, Kerala High Court gave a judgment saying Band is unconstitutional. Then Supreme Court, unusual. Normally they admit, decide. No, one paragraph judgment, Supreme Court, we approve what the Kerala High Court has said, Band is unconstitutional. And then of course Kerala judgment did not know Hindi. So the last paragraph of that judgment says, Band is unconstitutional. However, Hartal is permissible. The Kerala judge did not know the term than Hartal. Hartal is permissible. You see, Oxford Dictionary, Hartal is a term now, it's recognized. It is in the Oxford Dictionary, Hartal is there. Band is not, still not there. And therefore, this is let us say. The question is, okay, now thereafter now one more judgment has come, your Hartal is unconstitutional. So what Mahatma Gandhi did was unconstitutional. What is the difference between Band, Hartal? It's all a democratic exercise of your right. The question is, can you ever say people are indulging in unconstitutional things? Government, of course, has to do things according to the Constitution. If government does anything contrary to the Constitution, government can be hauled up. Other day, Advani, you see, must have seen a photo in all the papers. Advani takes the salute in Agra RSS camp and taking the oath of RSS, which is contrary to the oath under the Indian Constitution. The Indian Constitution specifies what the oath the minister is to take before he is sworn in as a minister, and it is contrary to that. And Advani is taken. So Advani, I can say, have done an unconstitutional thing. But if people, suppose I want to say, I don't want this constitution at all. I want a different type of constitution. I want something totally different. So people can do that. What people say or what people do cannot be described as unconstitutional. Your liberation movement, if you look at the constitutional angle, is not an unconstitutional act at all. It is an exercise of your democratic right. But of course, it can be illegal. Under the Constitution, government can bring a law. The law says you shall do this, you shall not do this. Of course, subject to reasonable restriction, which maybe ultimately Supreme Court may strike on the law or uphold the law. You may do something which is illegal, but certainly you cannot be accused of saying you are doing unconstitutional. Now that is why he judged me. Other day when I saw the Band here, I was thinking, look how peaceful Band is this. Because in this city, there is no other way of protest. In another city, perhaps we can lead a morcha, we can do something else. You can't do that. Your only way, you can close and say, we shut the door and stand in front of the shop and say, we refuse to do anything. That's a kind of demonstration. You can't do anything else in a situation like this. And I think there is nothing unconstitutional, and people have a right to say, we protest against what is going on. Liberation movement can be considered protest against what is going on. That's how we fought the British. How did we fight the British? By saying, okay, we refuse to listen to you. Satyagraha was that one. We refuse to cooperate with you. We do whatever, we protest, this kind of thing. Today, the Supreme Court and the Kerala High Court say, no, you can't do that. So that is down in the Supreme Court, we don't know. But you can never call what the people do is unconstitutional.
Excuse me. Just want to clarify what Justice Suresh said. I think what Sir have said is that Sir have referred about the referendum in Quebec also. So what the Sir want to say is that the thing is that if the people of Manipur wishes to be separated from India, and there is no power of the Indian government to resist it, I think it should depend upon people's not on the territory. I think it must be the point what Sir have said. Is it true?
No, I'm not following your question.
No, I'm not following. I'm asking the question, but I just want to clarify what the Justice said. May refer about the question of the referendum at Quebec also, Canada, Quebec.
Yes.
So the thing is that if the people of the Manipur wishes to be out of the India, and it's depend on them, the Indian government have no right to say against the wishes of the peoples of the Manipur. I think.
See, democracy means what?
Yes.
Democracy means wishes of the people.
Yes.
Ultimately, what says right to self-determination. As I said,
yes.
you look at this international component.
Yes.
Right to self-determination is a part of human right. Democracy itself is a human right. And therefore, if you are exercising democratic means to achieve a particular objective, certainly you are entitled to do that. And therefore, government cannot say, you cannot demand a liberation here. Government, of course, today what the government is doing is, government uses all repressive method to suppress what people are doing. That's all. But otherwise, you are certainly right to demand what you consider proper.
Just want to differ in under different angle. I mean, not in this topic, different topic. That regarding the cases of this armed forces special power disposed by the Supreme Court.
Yeah.
They have already affirmed that the armed forces special is a necessary thing in a situation like Manipur. The presently the coming to Manipur, Justice Reyes has witnessed all the extrajudicial things and over everything is happening against what the Supreme Court have not seen. Justice Reyes have all the witnesses.
Yeah.
So my question is that whether that decision made by the 5 judges of the Supreme Court can be reviewed again by a larger bench, or whether shall we file a petition to the Supreme Court for reviewing it?
When I say review, perhaps they will not review on their own. On their own, no. Because it's not technically review in that sense. What I say is, perhaps another matter from here may go to Supreme Court, or suppose somebody else files a petition Article 32 in respect to something what has happened here on the basis of the Armed Forces Special Powers Act, and when that petition comes up for hearing, the judge concerned feels that an earlier judgment of 5 days, a constitutional bench, is wrong and requires reconsideration. Then, of course, he can refer the matter to the Chief Justice to constitute a larger bench, and then his judgment can be confirmed or overruled. So it is review in that sense, not the same judges review on the sense that you find civil procedure court or under the Constitution. When I say reconsider, what the Supreme Court has to do is reconsider. As they take court of class case, then what did they do? Overrule court of class case by Keshwarananda Bharati case. This is what they do. So Supreme Court has to overrule the judgment. Perhaps in a matter will come before the Supreme Court at some point of time. And the judges feel strongly, suppose with all material, statistical details and things, you go, this is what happened here, you please, all is because of you have upheld this law. Strike out this law, and this is unconstitutional, and so on. So who knows? The bench may consider, well, this appears to be primarily unconstitutional, and in that event it may refer to another bench, and it may overrule.
Sir, my question is that if we move to the Supreme Court challenging the armed forces special power, I think it should be barred by the res judicata because it will
No, res judicata. The Supreme Court has done nothing like res judicata. Supreme Court may say, well, suppose you go and file a petition, and let us say under Article 32, challenging all provisions and so on. Then Supreme Court say, we are bound by the judgment, that is over. No. Suppose a bench, before you bring the matter, at that time feels strongly that the judgment given by this is how every time it happens. And this judgment requires reconsideration. Then in that event, matter is referred to the Chief Justice, and the Chief Justice then constitutes a larger bench. And the larger bench overrules the previous judgment, this judgment, and say, well, this is the law. That's what happened. In Korakran's case, Justice Subbarao, that was a constitutional bench. 5 days they sat and said, you cannot touch any fundamental rights. Then what happened? Then in the Keshwarananda Bharati case, the matter came before the 3 judges bench. They said, Korakran's case has to be reviewed. It's not the correct judgment. We want to overrule the judgment. So, they constitute larger bit of 9 judges. That's how Keshwarananda Bharati case went. And it was argued, and they overruled Korakran's case. This is how it happened.
Thank you.
I want to ask you a question. Does the Armed Forces Special Powers Act permit an army officer to slap a person?
Yes.
Yes? Where did you get that from?
Pardon?
Does it permit an army officer to slap a person?
It is not only the slapping, it is
Does it permit him to slap a person?
Not only the slapping, but even to killing.
It doesn't permit.
It just permit.
No, this is a wrong conception, please. That's what I was trying to tell you. No army officer can touch a single person. If he finds a person with a gun or with a grenade, he can shoot.
No.
Just a moment, please. I'll make it very clear. Armed Forces Special Powers Act does not permit the army to even interrogate a person. Suppose you catch a person on the street, army has no power to take that person and ask him questions. Army has no power to touch, torture, beat a single person taken into custody. The Army has only this limited power that when it sees a person engaging in insurrection, engaging in armed activity, throwing a bomb, then they can take up a gun and shoot that person. If the Jawan's life is threatened, they can do it. Shoot that person. So, once again, what I'm trying to say is, you take it for granted that the Armed Forces Special Powers Act today is in force in Manipur. Army has no right to beat. Army has no right to torture. Army has no right to fire into a crowd. Army has no right to interrogate. So you assume that the Armed Forces Special Powers Act is going to be there for the next 100 years. What will you do? What will the lawyers of Manipur do? Act is going to be there for 100 years, let us say. Maybe by luck it will be reviewed after 5 years, 6 years. It is there today. What will we do? We will file cases repeatedly against the army. Look at the inquiry reports. The district judges of Manipur have bravely said, very bravely they have said, that the army had no right to interrogate. The army had no right to take him into custody without first informing the police. That before they did the raid on that person's house, I'm reading the report just now. Before they do the raid on that person's house at midnight, they should inform the civilian police and take them along. That when they do the raid and they seize the man, a witness from the area should be present and he should sign that I have seen. If any country-made revolvers is taken, the witness from the area should be taken and a neighbor should be taken and the sign should be taken. So don't assume, it's very wrong if we spread this information that the Armed Forces Special Powers Act gives the army the right to do what they do, because then they will continue doing it. And they will say Armed Forces Special Powers Act, we will say Armed Forces Special Powers Act. It will be an excuse. It does not permit the army to do these things. You show me anywhere where it says that you can take a person into custody, slap him. I'm only talking about a slap. I arrest you today, I take you to the army camp, I slap you. Where is the right under the Armed Forces Special Powers Act? It's an offence.
But there is no right for the
That is a separate issue. But let human rights activists not say in Manipur that the Armed Forces Special Powers Act permits the army to touch a civilian.
Mr. Colin, I'm disturbing you. I'm not in the exact provision of the sections of the section number 4, but I think there is a word on mere suspicions. On mere suspicions, the word mere suspicion is very dangerous now. Because of this, I said that the access power is given to the armed forces.
No. On mere suspicion, he may open fire.
Yes, this is the question, sir.
That is a different issue. I am saying you are taken into custody. All our boys are taken into custody.
No.
On suspicion, yes. On taken into custody. When you are taken into custody, can you touch him? Look at the do's and don'ts of Supreme Court. Do not use force against a person unless he is trying to escape.
Yes, okay.
Do not interrogate the person. Hand him over to civilian power immediately. You have no right to interrogate a person. So from human rights point of view, let no human rights activists in Manipur say that any of the actions of the army are permissible under the Armed Forces Special Powers Act. Because they are using it as an excuse, we should not allow them to use it as an excuse. Even if the act is not reviewed, they cannot do any of these things. Revenge killings are not permissible under any law.
I will clear this way. I am repeating the question again. I think that word this has come to my knowledge, but I don't have the exact provisions of the law in my hand. But on mere suspicion, the person may be shoot, and that may cause to death. Let me conclude to my conception. That on mere suspicion, any person may shoot, and that shoot may cause to death. I think this may be the exact provision of the law. If that is so, then on mere suspicions, a person may be shoot, and that may should cause to death.
Correct, you are right.
I'm coming to the point. I'm not clear this way. I'm coming to it. Oh, it is here it is. If he is of the opinion, he means the non-commissioned officer below the rank of the non-commissioned officer. If he is opinion of that it is necessary to do so for maintenance of the public order, and after giving such due warning as he may consider necessary. I repeat it again. If the person is necessary considered, if he thinks that it is not necessary, it is a different question. Necessary, fire upon or otherwise causing force even to the causing of death against any person who is in contravention so and so and so. So, I think this is the word which has been using in this provision, license to the to the armed forces to kill any person on mere suspicions.
In a situation where the situation of public order or is like to break the law. Not just like that.
Public order means Manipur is under disturbed area since 1980.
No, you're misunderstanding the act. What you are saying is...
It is there. Read that. See, in what situation they can do. See, what they do of course is wrong. But what they can, legally what they can do is, in a situation of public disorder or order, where there is a prohibition of assembly or anything of that kind, then of course, if they find it necessary, they can shoot. That's the incident.
Yes.
Therefore, suppose the police, the army comes here, we are just sitting quiet here. Can they shoot?
Yes,
no.
I think so. Yes.
There's no provision there.
But I'm coming to the point because I'm going to explain.
They're doing. So what we're doing, we have to protect by the case, and what they've done is against the law.
No.
Please don't propagate. 1 second. Please don't propagate this. This is not at all what Supreme Court is saying. This is not at all what anybody is saying in the country. What the Act says is, if a person is engaging in an act, not generally, like generally the state is disturbed. He is engaging in an act which will disturb the peace. He has got arms. It is necessary to control him. Then don't tell him, Mr. So-and-so, please put down your gun. Not necessary, you take a gun and shoot him.
Yes.
That is all the Act is saying. It does not permit a person to take an unarmed person and shoot him. It does not permit the army to take an unarmed person and even slap him. It does not permit the person to take an unarmed person into custody and then do all kinds of things. Please don't propagate that. That is not the Armed Forces Special Powers Act at all. The Supreme Court was never put to that question that this Act enables you. Disturbed area, anybody in a disturbed area, I can catch him today, take him to the toilet and shoot him. On suspicion, I'll shoot him. No. Please don't say that. Even the army advocates are not arguing that. Even the army advocates in the Supreme Court are not arguing. So please understand, it's a very restricted act.
I got your point, but still I'm not convinced about your point because the word using...
I would like to interject there, Mr. Mohammed, that Mr. Colin, you are right. That the Act does not say so. But this is a matter of the abuse and access of the armed forces. This is the question. Abuse and access.
Abuse is a separate issue.
It's okay. It's a separate issue.
That's why I'm saying, my dear friend, what you do is, you assume now, suppose mentally you assume that for 5 years Supreme Court is not going to interfere, judgment is there. Still, whatever the army is doing is wrong. Whatever they are doing is wrong. They cannot on suspicion beat a person, kill a person. No. Unless that person has got some guns or throwing some bombs, they cannot touch a person. So you fight your cases fearlessly. You come out with your propaganda fearlessly. You write your articles fearlessly. And you go to the Supreme Court and tell the Supreme Court there is misuse of the Act. Misuse 100%. Every day there is misuse. But don't ever a human rights activist justify what the army is doing, saying that army can do this because the Armed Forces Special Powers Act gives them the power. There is no power to do all this. And just read the inquiry reports of these district judges. They are not high court judges, but they have written such beautiful inquiries. You cannot come at midnight and break down the house of a person without first taking the local police along with you. Brilliant report. Just see it.
Just a reflection on this. Even the judgment which was written on the Armed Forces Special Powers Act, what even the army lawyers have done was basically read the act and put it as it is. The practice part of it never came in. They just read the act and say, well, if it is, this is what Colin was saying, if it is a question of an insurgent trying to shoot at somebody and the army can shoot at him, well, it should be constitutional. And after all, there is a long list of do's and don'ts which the army has to follow in any case while undergoing this this operation under disturbed area, then it sounds perfectly logical in the eyes of the Supreme Court to agree to it. But in practice, the problem is, even though there are some safeguards given, there is no remedy to it when these are violated. As a result, the whole atmosphere that is being created today, when even a sitting judge is tortured and nothing happens, now a myth is created around Armed Forces Special Powers Act, wherein everybody thinks that they are above the law and they can do whatever they want and they can get away with it. Now the question that is lying in front of us is, I think there is a in terms of intentions, what Colin is saying and what Bombay is saying, there is no difference in terms of intention. What Colin is saying is the Armed Forces Special Powers Act doesn't permit that, so let's fight it by keeping aside the Armed Forces Special Powers Act, even if it is still prevalent. What Momo is talking is, I think, in my observation, is more in terms of practice. In practice, they are still doing it, and there is no remedy in which we can fight it out. Now, the question is, if the lawyers are ready to fight it, and let's say the lawyers have now the courage and the intention and the energy and capacity to fight, how do we fight is the next question.
That's the next question.
Yeah, how do we fight it is the next question. So can we throw a little light on how do we take the next step? Do's and don'ts are violated, so what? The Commission of Inquiries have written that they are wrong, so they get a transfer, they get their this thing. What do we do now from here? Is a moot question. Unless and until there is a proper remedy, no right can be justiciable. A proper right. That's the problem. That's where we are, I think. So can Colin throw a little light on this?
You start with the judge's case. It is a winnable. It is 11 years old. The inquiry report is in his favor. Namely, that 4 army officers have tortured him. Right? Start with his case. Have a public delegation to the Chief Justice here. Request him, sir, please take up this case. There's a public demand that this case be heard. In the papers, write about the case, say that the High Court should hear this case immediately, and pressurize the High Court to hear the matter and decide the matter, one way or the other.
And insist on the officer being prosecuted. Because their competence is not the thing. Insist on being prosecuted. There should be directed by the High Court to directing the government to take all steps for prosecuting the army officer. See, you did not wait till a disappearance. You did not wait till injury is caused. Suppose the man is now in the pronounced state. Now, you can say he is tortured. Okay? He is not being prosecuted by anyone. The army officer is not being prosecuted. File a writ petition in the High Court. They cannot be suspended. This is what they have no power to torture. They have no power to do this. They have caused all these things. And therefore, you direct the government to prosecute the army officer and take steps and report to the High Court. You can do that for up to midtime. Something like that. So, ultimately, judiciary has to be more active. If it can do that, it will want to.
Secondly, these cases about, and they killed 2 or 3 people and injured some people. We met some of those persons. The army has given 20,000 rupees for each person. And I think 4,500 for the injured. Take up that case. Army has no right to shoot into a crowd. Look at the Supreme Court direction. Do not use any force after arresting a person. Let's look at it. Do not use 3rd-degree methods. After arrest of a person by member of the armed forces, he shall not be interrogated by the member of the armed forces. And look at this. Do not fire into a crowd. Clear directions of Supreme Court. How did they fire into the election crowd and kill 3 people? Fight a public interest case.
Is there any punitive action if the armed forces give to the contrary? In the Act.
Not in the Act, but it's very well settled that if you open fire on innocent people, you should be removed from the force. Tulsi Ram Patel's case is the railway case where the Supreme Court said, Tulsi Ram Patel's case, the railway employees engaged in Maramari during the railway strike. Supreme Court says when a government servant breaks the law, you can give him notice under Article 311, sub-Article 2. Give him notice, hear his explanation and remove him from service immediately. So Article 311(2) gives the government the power to remove a government servant for misconduct and crimes. Now a police officer who opens fire on a defenseless person and kills him, Article 311(2) can be immediately applied. He can be dismissed from court. 1. He can be prosecuted for murder. What else? So there are clear legal provisions for the prosecution of an army officer who opened fire on a defenseless person.
But the whole crux of the problem is that we have not seen much of this prosecution, which is exactly why I think this impunity we talk about, this security forces.
By and large, what's happening here, as we see now. Okay, you go to the police, or they complain, police keep the matter pending, do nothing beyond that. Army officers just get away. Police take no action against the army. They don't even apply for sanction for prosecution or investigation. That's how things are just lying. Only in some habeas corpus petitions, the matters come to the High Court. No other cases have not come to the High Court. I think now you have to take every case, because you can't go to the police and so police do nothing. Take every case to the High Court. Suppose somebody thought to take the case to the High Court with a prayer that this is the doctor's evidence, this is the statement, this is the photo, show the photo, put all these things, and these are the statements from the police station, whatever recorded, and on the basis, please, prayer will be direct the government to sanction prosecution, arrest and prosecution of the officer concerned who are involved in this particular. That your prayer. Come with repeated petition in the High Court. High Court will give publicity. Today, not a single case of that has come to the High Court. So I think you should do something like that.
Things in the papers, newspapers. Journalists as a whole, I think we have a bit of problem in reporting on the judges, because there's always this contempt of, what was that? Contempt of court thing hanging on the thing. So most of the journalists are very wary of writing on judges particularly. So what are the areas where we can touch and what are the areas we can't touch?
You can touch any area. Only thing is you use polite language. You can touch any area, you can criticize the judge, you can criticize the judgment, you can say the High Court is going too slow. That is not contempt of court.
And don't attribute motives.
Don't say that he's corrupt, he's like this, he's somebody's brother-in-law and all that. Don't say all that. But you can say that the judgment is wrong. You can say that he's taking too slow. Of course you can say.
Passing a judgment on a judgment is not wrong.
No, certainly. Just as judges decide, the litigants have right to decide. The judges also. The judge good or bad. There's nothing wrong in saying that. So certainly, I've written articles openly against what the Supreme Court decided. For example, when the Supreme Court upheld Dada law, I wrote a very strong article which appeared in Amrutbazar Patrika at that time. I said great betrayal by the Supreme Court, headline, and a strong use as strong language possible against the Supreme Court. I've written judgment against article against Ayodhya judgment. I've written many articles against the Supreme Court judgment. This is wrong. Certainly you can. Only thing is, you should not attribute motives to the judge. Okay, this is real, as he says, related or Patrika Kodo. He says this, analyze, say this normal judgment. Of course, you can say this judgment is wrong. There's nothing wrong with saying that.
Please elaborate a little on what you said about Sweden. This whole concept of contempt of court is a very Anglo-Saxon concept. This was what he was explaining. So maybe we can share.
This, as you're right.
In terms of one party of the case, if he comes to the press and says something,
okay,
see, we have a case in the court.
Okay, you can certainly do that. Suppose there is a case pending, let's assume, and witness examined in the court of that day. Okay, you are there, you can certainly report about it. And then the other side cross-examine, whatever, you can report about the court proceedings. There's no law, we say you should not report about the court proceedings. Privately, suppose I tell a matter, this is in the court, but one party comes to you, he doesn't go to the court, he comes, though he has filed a case, he comes and says, look here, this is a case I have filed against other men, publish this. Now there, you have a risk of publishing it, because the other man may say, you have defamed me. Because suppose a false case.
then of course press can be prosecuted for defamation, not for contempt of court. So court proceedings you can report, but as between a private litigation, suppose I file a case against say somebody, and then he has filed a written statement and put in the court, matter is pending in the court, but I don't go to the court, when I come to you, so here is a case I have filed. Then if you want to report, you go to the other man also and find out what this is what you want. You can make it in both sides, okay, that's up to you. But otherwise it may amount to defamation.
Suppose if someone files a case and he brings the case me and say publish this, that could amount to defamation case if the
suppose I tell you, the case involves some allegation against the other side, and though the case is not tried, case is still pending, nothing has happened, you don't even meet the other side. What this man has said you write and you publish, it may amount to defamation. If there is defamatory statement, so that man may take it to task. If there is nothing, there may be nothing. So it all depends upon the fact, and you have to be careful. You can't just publish just because the complainant has come to you or plaintiff has come to you. The defendant, you don't go to the defendant, you just publish. So that may amount to.
Take the opposite state. Take the opposite side's point of view also.
Also, but then you have your own, you have to assess what is proper, what is not proper, to what extent.
Because reporting on courts is always confusing also sometimes.
Yes, sometimes it comes like that. So what normally the papers do, they are not sure, they take an affidavit saying that this is what I have said, and something I think all bit of risk is there, always. Yeah, but then no contempt, it's written about defamation. No contempt. Yeah.
Each paper has a law reporter in the courts, and the next day you read about the proceedings. We via law reporter, and it's all reported.
Those that's a reported here are more on
widows and children who are the victim of the ethnic conflicts and ISIVs, and widow and children of the insurgency, victims of the insurgent groups. So can I file PIL on behalf of these women and children for getting their rights about the rehabilitation and the livelihood to the state?
Rape was committed by the insurgents.
Yeah.
And police have done nothing.
Nothing.
Okay, you can file a case. Why not?
Yeah. By the time the government's situation, financial crisis is still very dangerous, very ferocious. The financial condition of the state is very deteriorating. So how can they give response? So what? Yeah, state. How can they improve? We know the government is powerless. They are very much poor.
Basically, what it's trying to say is the government is, as stands now, unable to pay even the salary of the state employees. So in this situation, how could the state be made to pay compensation to these widows? Or
it all depends, that is all in the future when a case is filed, case has to be decided and an order has been passed or a decree has been passed. After passing a decree, what happens is special execution comes. At that stage, you can decide what you should do. In one case, you know what I did? I can tell you as a judge. There was a case of an employee before me who had not was dismissed from service or something, and then I upheld his case. I gave a judgment in his favor, and thereafter I said all his arrears of salary, which was 30 or 40,000 at that point of time, was due. That also should be paid. Now, nobody went in appeal against my judgment. My judgment was pending, was upheld. In a sense, nobody went in it. Local judgment remained. So after 3 or 4 months, this employee who succeeded before me came to me and he said, "Sir, I've not been paid my salary, though you have given a decree of this much amount, and I really don't know what to do." I told him, apply for execution of the decree, civil suit decree. So I applied for execution decree, and he asked me, "Sir, what do I do?" I said, "Attach." Ask for attachment. What is the attachment? I said, "Which department?" He said, "This is a particular department." I said, "There's a furniture, fixtures are there in that department that will cover your value." Ask for attachment. So I granted attachment of the fans, fixtures, tables of the second date. I said, "Go to the bailiff and attach." Bailiff went there to attach. Then the government realized they were not paid. They came run to the High Court saying, "Sir, This is what happened. The High Court just said, you have to pay, you have not paid, you pay first, otherwise the attachment will continue. And the attachment will sell, and you get your money. Don't worry about that. Government has money or not, you are not concerned. Government has property, secretary is there, attach secretary. Why not? You can do that. That's not a problem. You can certainly work without this kind of holidays. But that desire is not there. That's the main problem.
Why come here because of our holidays?
Come here because of holidays. Okay.
With due respect, my lord, when your lordship was judged, then what was your reaction against this long vacation?
This long vacation, I tell you, oh yeah, even at that point of time when I was a judge, I written to the Chief Justice and also offered my service. I said, I'm ready to work this vacation, and I said, we don't require vacation. I said that. I had suggested other things at that time. Our salary was very low at that time. So I said, you do one thing, we work during the vacation, give us some benefit in terms of salary. So that judges will be happy to work. You see, we have, those days, we used to have 6 weeks vacation, summer. And you go out here and there for 2 weeks or 3 weeks. Then what do? Come back and relax, do nothing. Instead of that, I say, we are ready to work. I've said that. But the system would not agree. I've written articles also. We had a seminar, workshop the other day in Bombay. Snap of all his holidays. He said, it's not required. We have said that.
One thing that coming to your point, sir, in connection with this People's Independent Inquiry Commission, some group of people, some section of people pose questions that the government of Manipur had already instituted inquiry. Then some of them are still pending, and some of them have already been concluded and submitted the report to the government. But the government has not taken up any action till now. In such a situation, now you people are organizing People's Independent Inquiry Commission. Then what benefit will give to the people? And in this connection, my humble request is that what is your message to the people of Manipur?
Our objective in holding this inquiry is to create public awareness. There's nothing beyond that. Ours is a part of a democratic exercise of right to information, telling the people what has happened, pointing out what should be changed. We only do that, we can't do anything beyond that. But this kind of democratic exercise you have to do. If people keep quiet, nothing will happen. It's only creating public opinion and public awareness. And perhaps our report may help you when you fight your legal battles. That's all. Beyond that, nothing. We are not interfering with anyone. Journalists do this work. You are at the lawyers, anybody can take them. Suppose something happens. You can go and investigate, and now no law will say you shall not investigate. You can investigate. We, our human rights group, also come and say, if there is human rights violation, government has done nothing, people feel strongly, okay, we are invited. Okay, we look into it, we comment upon it, we publish it, we give publicity, we tell the other part of the country, and look here, this is what goes on, and create public opinion. That's the main idea.
Sir, the problem here at High Court of Independence here is that a lot of habeas corpus petitions are still pending. The interesting thing is that the case, when the cases are listed, the Canadian counsel or the petitioner regularly pray for adjournment. Then the freedom, families of the involuntary disappearance